Thank you, everyone, for joining us on a Monday night to talk about a Maryland amendment for environmental health and justice. We're so excited you could join us. So who's speaking now is Caitlin Schmidt. I am the Legal and Policy Director at Waterkeepers Chesapeake. Waterkeepers Chesapeake is a coalition of the 18 different waterkeepers, riverkeepers, across the Chesapeake Bay region, spanning from Pennsylvania and Maryland and Virginia. So we're really excited to take on this work in building an amendment for a healthy and healthful environment, for pure air, for pure water, so that we all can have a healthy place to live. Just one housekeeping item in terms of questions. We've got lots of folks on the line and we'd really love for your questions. So as each presenter is speaking, feel free in the chat box. You can type in your questions there and submit those, and I'll start saving them so we can ask each presenter at the end of their presentation whatever questions you all have, and I'm happy to moderate those for you. So joining me today is Delegate Vaughn Stewart, Maya Van Rossum, and Tamara Tolzo-Laughlin. We're really excited to have them. And let me just go ahead and kick it off to Delegate Vaughn Stewart, who is a Democratic member of the Maryland General Assembly. He's from District 19 in Montgomery County, but he's also the lead sponsor of the Maryland Green Amendment for Environmental Health and Justice. We're really, really excited to have him as a sponsor. He was a powerhouse in Annapolis last year, bringing in multiple different environmental laws. And we're really, really great and pleased to have him as our lead sponsor of this effort. So Delegate Vaughn Stewart, do you want to go ahead and take it away?
Great. Can you hear me?
Yes.
Yes.
Okay, fantastic. Well, thank you all very much. It's very exciting to be on the call tonight and chat about what I think is a really, really important topic and a bill and sort of a concept that I'm really excited about. So I think that I'll sort of go into my slides here. So this is a little title slide. So a little bit about myself first. So as Caitlin said, my name is Vaughn Stewart. I am a member of the Maryland House of Delegates representing District 19, which is, for anyone who's familiar with the area, sort of in the middle part of Montgomery County. And this sort of idea about, and this kind of conflict between public health and environmental justice on the one hand, and corporate profits and sort of big business pollution on the other hand, is something that's really personal to me. I grew up in a small town in Alabama, actually, and it has been dubbed Toxic Town USA by the media because Monsanto used it as a dumping ground for PCBs for decades. So there was a massive plant there, and Monsanto, without notifying even their employees, much less the public, they dumped all these particles of PCBs into both the air and in the water. And as a result, my hometown has cancer rates that are 5 and 10 times the national average. And I personally, even though I am still pretty young, I like to think at the ripe age of 31, I've actually beaten cancer. I've had and beaten cancer twice now, both before I was 30. And the most recent time, which was in 2017, I had non-Hodgkin lymphoma, which is the cancer in all the studies that is most tied to PCB contamination and PCB exposure. So in all likelihood, Monsanto basically gave me cancer. And I think that if this movement, if this idea behind a right to a healthy environment, a right to clean air, a right to clean water, if that existed in more states and that existed and was enforced strongly in my home state of Alabama, I may not have had to go through that experience, which was, no fun. And I wouldn't have as many people that I know that have either been diagnosed with cancer themselves, or in some cases, I have some friends who are not too far from my age who have passed away after growing up in my hometown. And so this is an issue that I think is really personal for me and personal for a lot of folks who are advocating for it, because we're really talking about tangible lives here. This is not some sort of academic concept, even though it quickly gets wonky with all the judicial opinions. This is something that really is tangible and it's personal for millions of Americans. So moving on to the bill itself, as I'm sure most folks realize, what the constitutional amendment for the environmental health and justice basically states is that in this case, every Marylander has the right to clean air, pure water, a stable climate, and a healthy and healthful environment. So it's pretty simple. It's, to me, something that I think is immediately resonant for most people when they hear it. In fact, a lot of folks I've talked to have said, how is that not already a right? How do I not already have the right under either a state or the federal constitution to something so basic as clean air and clean water and a sustainable climate? So I want to talk a little bit about why this amendment is necessary and why the status quo is insufficient. So, as I'm sure people realize, by embedding this right into the state constitution or into a state constitution, it's a much more permanent act. It means that when any decision is made by an agency or when any decision by either a private actor or an agency is reviewed by a court, this is something that is of the utmost and highest obligation to consider. And unlike a statute or a regulation, it can't be changed at the drop of a dime merely because either the legislature changes hands in terms of the political party, or maybe a political party has a change of heart, or a new governor is elected. This is something that is going to be a permanent fixture of Maryland's constitution, and that would be an extremely difficult thing, especially given how popular I'm sure it is to be, that it would ever be taken away. And the second point that I want to emphasize, and I think this is sometimes lost in these debates, is the legislature in Maryland is part-time. We only meet 90 days a year. We're actually coming up on the midpoint of this year's legislative session. So it runs from January until early April. So the point I was making was just that we're only in session for 90 days out of the year. And so when you have something really pressing or something that can be really catastrophic for human health that's either about to be authorized by the state government or about to be pursued by a private actor, having a legislature that meets only 90 days a year is pretty inconvenient. Because even if we wanted to stop something imminently, it has to go through the entire legislative process. It has to survive a veto by the governor. And the legislature is just inherently, even if they're full-time, but certainly in Maryland where you have a part-time legislature only meeting for 3 months out of the year, it's not going to be a quick enough actor and a quick enough mover on some of these really thorny things that could imminently harm people's livelihoods. And so courts are the natural place for this, because a court can grant an injunction over something like fracking or a power plant or some sort of extension or license or wetlands license. A court can act immediately. They can act overnight in a matter of hours on an issue that would take the legislature, in a best case scenario, months to do. So that's another, I think, really positive feature of this constitutional amendment. So moving right along, as y'all may know, Pennsylvania has really been the model for us in crafting this, because after a wave of states passed something that resembles the amendment in their state in the 70s, it really was not until recently that the Pennsylvania courts have given real teeth to this language, and they've taken seriously that this is a real constitutional right, as opposed to just kind of written it out on their own whims. And so Pennsylvania, I think, really puts a fine point on a distinction that is important, because I've already heard from my colleagues fears that, oh, well, is this going to be used to justify every single frivolous lawsuit that someone brings, and we're going to have all these people flooding the courts, and it's going to be this huge mess, and we're going to have to spend all this extra money on judicial administration? Or is this something really that courts should even do? Shouldn't the legislature always retain the ability to have policy-making authority on these on these areas that are sensitive to corporate profits, for example. But I think looking at what's happened in Pennsylvania recently, we see that I think these fears about the amendment are misguided. So first, as we've seen in the two cases on the PowerPoint that I mentioned first, one is Robinson Township and one is Clean Air Council. We're talking about basically pipelines and fracking are the two instances and the two fact patterns that courts latched onto in Pennsylvania to utilize the amendment and to say that this infringes on Pennsylvanians' right to a healthy environment. And so those are such extraordinary, clearly threatening, clearly instances of imminent harm. I think that it speaks to courts' ability to weigh the pros and cons and to act in cases where they're kind of the actor of last resort. In either of these cases, the legislature just can't act, especially Maryland, can't act quick enough to be a fail-safe for some of these extremely egregious environmental harms that will imminently harm people and affect people's lives. And then on the flip side, we see in this Greeton Properties case where the court rejected a claim that a new student apartment building violated someone's constitutional right, the Healthy Green Amendment language. And so this is an example to sort of, counter the claims from a lot of critics of our effort here that this is just going to be used every time a new development comes around and someone says, oh, the view out of my window is impeded, or, oh, this has ruined the character of the neighborhood, yada, yada. I think the Pennsylvania courts have done a really good job of showing that that's not what we're trying to get at here. We're talking about fundamental, real human health considerations, not merely, someone being slightly inconvenienced by a change to their neighborhood. And I think that courts in Pennsylvania have proven to be extremely adept in parsing out those two cases and utilizing this amendment and enforcing it in cases where it was obviously needed and where the state legislature was not necessarily going to act. And so now I just want to, now that we sort of have those basic talking, considerations out of the way, I just want to transition to where we're at in Maryland, which is that we have a hearing date coming up in February for the bill. And every bill, unlike DC or unlike Congress, in Maryland, every single bill that's put in gets a hearing. And so we're right now in the process of accumulating witnesses, both to come down here to testify in person and also to submit written testimony. So certainly anyone on the call that's interested in doing either of those things, either because they can make it to Annapolis to testify in person, or if they just want to email my office and we can submit the written testimony for them into the record, that would be really, really helpful, because essentially the committee, I'm on what's called the Environment and Transportation Committee. That's where the bill is headed. And in Annapolis, the committees really have primacy over these issues. And so if a bill gets out of a committee, 99% of the time it's going to pass the entire House. And in a lot of instances, if something can get out of the House, especially on an issue of environment, of the environment, it'll also get out of the Senate. So if you want to direct your energy to help us with this, we would absolutely take your help. We will absolutely take you up on that offer. Or your acceptance of my offer, if you will. And the most helpful things you can do, if you cannot testify in person or submit written testimony, if you do live in Maryland, just reach out to your legislators, send them an email, shoot them a phone call, say that we've got a hearing coming up in a couple weeks. Delegate Stewart is putting in a really important amendment to the Maryland Constitution to guarantee things that are fundamental, like clean air and clean water. And you really would hope that they support the effort. And even if they're not on the committee, any voice that we can have that would be supportive of this effort would be immensely valuable to us. But especially if you happen to be lucky enough to live in a district or to know someone who is on the committee, whether they're a Democrat or Republican, if you could reach out to them in some sort of way, some sort of fashion between now and the hearing, that would be really, really useful for us. So in closing, I'm really, really energized by all the folks that are on the call. I really appreciate your support for this idea, and I really appreciate the advocates who have made this happen. I'm just merely the guy who's basically introducing the legislation, but this is an idea that has been pushed to the forefront because of the work of activists and advocates and environmentalists to see how crucial this could be and how much of a game changer this could be for the entire country, especially in the midst of the climate crisis that we're in. And so I feel really privileged and really fortunate to be able to carry this banner and this torch in Maryland. And with your help, I think we can get this done and we can make a cleaner and a healthier environment for generations of Marylanders to come. So thank you so much again for taking time out of your night, especially on such a big night with the caucuses and whatnot, to spend some time chatting about this important topic with us. Yeah, I'm happy to take questions.
One of the first questions we got was, where do we reach out? I might be able to testify, and what is the date of the hearing?
Great.
The date of the hearing is actually on February 19th. The House bill number is House Bill 517. You can go to the Maryland General Assembly website and find all of the bill details there. And in terms of where do we reach out, this is Caitlin speaking, and I'm happy to take any questions or emails you have. But also, I have written instructions on how you can submit written testimony to the House Environment and Transportation Committee. And on top of that, we even have Waterkeeper Chesapeake has an action alert that you can send in. It's a form email that you can send directly to your senator or delegate. All you have to do is put in your zip code so the system can figure out who your legislator is, and then those automatically go in. So I'm happy to share that information after this webinar. Any other questions? I have a few myself, but I wanted to give other folks some time to go ahead and type some questions in the chat box. While folks are typing out, Delegate Stewart, what will exactly need to happen for the bill to become law?
Yeah, so that's a great question and something I neglected to mention, but there's an extra hurdle here because we're talking about a constitutional amendment. So normally for a bill to become law, it's got to pass the Maryland House, it's got to pass the Maryland Senate. We have Democratic supermajorities in both the House and the Senate. And so you would hope, though this is obviously not a slam dunk, that we could get most, if not all, Democrats on board with this idea. But because it's a constitutional amendment, it has to jump through one extra hoop, which is that it has to be submitted as a referendum to Maryland voters. And so if it passes this session, my understanding is that there would be time for it to be placed on the ballot this November 2020. Otherwise, it would be in the 2022 ballot. Maryland has off-year elections for most of its offices. And so, yeah, so basically we have the House, the Senate, and then the voters. But I think in a lot of ways, that last step, sometimes I don't mention it or I de-emphasize it because I actually think this is going to be a big no-brainer if put to the voters. I think this would be an overwhelming majority, 60, 70, if not higher percentage of the vote. Marylanders, when polled on issues on the environment, express overwhelming concern for example, the Chesapeake Bay's health, and overwhelmingly believe that we need to act swifter and bolder on climate change. And so I really have very little doubt that Marylanders would approve the amendment in large numbers.
Great. All right, we'll do one more question. It doesn't look like there's any more in the chat box. But you touched on this lightly, but maybe if you could just address it again. How is a constitutional amendment better than legislation? Maryland has a robust system of environmental rights, so why do we need something more?
Yeah, absolutely. Well, I think first of all, it goes back to most of the environmental rights that Marylanders enjoy are in statute. And so to have a constitutional right would make it permanent and would make it essentially immune from the changing political winds that we may face in the future. And so it basically would put sort of a stamp on it. But also it has a stronger weight. Any sort of constitutional right as any lawyers in the chat will know, has much stronger weight than any sort of statutory rights. And so it's something that courts can wield regardless of whether a certain act fits within a certain statute.
Great. Well, thank you so much again for joining us, Delegate Stewart. I know you've got to make your way over to the House floor for some potential votes, but we're so so happy that you could join us and that you are our champion of this work. We're very grateful for you, so thanks again.
Absolutely. Really, the pleasure is all mine. I really owe a great debt of gratitude to all the Maryland organizers, Caitlin, and of course to Maya for putting this issue on the front burner and making this a priority nationwide. I'm merely the guy dropping the bill, but I am really, really pleased to play a small role in this much bigger and much more urgent fight. So thanks again.
Awesome. Thank you. All right. So up next, we've got Maya Van Rossum. She is not only the Delaware Riverkeeper, but she is the founder of the Green Amendment for the Generations and author of the Green Amendment, Securing Our Right to a Healthy Environment. If you haven't read the book already, you definitely should. It's an amazing book and can really show you how much these amendments can mean to communities across the country. And she's been a powerful advocate for these across the country. So we're really happy that she could join us. And thank you so much to For the Generations for pulling together this webinar. So with that said, Maya, do you want to take it away?
Great. Thank you so much, Caitlin. And thank you, Delegate Stewart, for your great leadership on this. Both of you, really so grateful to be in this with you when it comes to trying to advance the Maryland Green Amendment. And so again, I am Maya Van Rossum. I've served as the Delaware Riverkeeper and leader of the Delaware Riverkeeper Network for over 25 years. And the Green Amendment for the Generations movement that I've now also founded and head up at the same time is really an outgrowth of my work as the Delaware Riverkeeper, and realizing and recognizing that our current system of environmental protection laws in Maryland and in every state across the nation and at the federal level are fundamentally failing us and have been fundamentally failing us from their inception. And that's because they are much more focused on accepting pollution and degradation as a foregone conclusion, and then focusing on reviewing the harms that are going to come and figuring out how to permit and manage them, but still allow them to go forth. They are not focused on how do we prevent pollution, how do we prevent degradation from the get-go. And it is based on that realization and based on our success in the Commonwealth of Pennsylvania, giving people a constitutional right to a healthy environment, that this idea of advancing a national Green Amendments movement came to the fore. And so the mission of Green Amendments for the Generations, again, my second hat in this second organization, is to inspire and support the passage and implementation of Green Amendments in every single state across the nation, and then ultimately at the federal level. And you have heard earlier, right, you've heard the language of Green Amendments, but then you've also heard about the Constitutional Amendment for Environmental Health and Justice. The Constitutional Amendment for Environmental Health and Justice is Maryland's version of a Green Amendment. So just so that folks aren't confused, but I will be using the Green Amendment because that is the goal and the focus, and that's what this Maryland effort is a part of. My goal today is to quickly talk with you a little bit more about why we need a Green Amendments and what they do. I started with the basic fundamental premise about how and why our current system of environmental laws are failing us. That is really amongst the most important points for you to realize and recognize. Our current laws are focused on permitting and managing pollution degradation, not on preventing harm from the get-go, from the start of the decision-making process. Let me go. Sorry, I'm clicking wrong. And so that is something that a Green Amendment would change. Now, as we all know, right, in Maryland and in every state across our nation, we have all sorts of fundamental rights. We have the rights to free speech and due process. We have private property rights. We have the right to bear arms. but in constitutions across our nation, we do not have a right to pure water, clean air, a stable climate, and a healthy environment. It just fundamentally is not part of the package of rights. And as Delegate Stewart said, when people realize that and when they recognize that, they are truly stunned and shocked, because how many rallies have you been to, how many speeches have you been to when you've been told you have a right to a clean and healthy environment? Well, it is true that we as people here on this earth should have an inalienable right to those things. But if they are not given constitutional recognition and protection, then fundamentally, legally, it is a powerful concept and it's powerful language, but it isn't really truthful and meaningful under the legal rubric of the United States of America. And that's really where Green Amendments kick in. They are a fundamental transformational change when it comes to environmental rights recognition and protection. And they ensure that environmental rights are given the same level of protection as all of those other fundamental freedoms we hold dear, like the right to free speech, like private property rights. With a Green Amendment, fundamentally, legally, constitutionally, our rights to a healthy environment are given the same greatest strength as all of those other fundamental human, civil, and political rights we hold dear. Now, not just any language in a constitution about the environment rises to the level of being a Green Amendment. There are elements that are really necessary for a Green Amendment. And actually, if you go to the forthegenerations.org website, we have a checklist that gives you all of the elements that are really important for a Green Amendment. But there are some elements that just are fundamentally important and must be in place for a constitutional amendment to be considered a Green Amendment, which gives this highest recognition and protection. First off, the language must be placed in the Bill of Rights section of the Constitution. It can't just be placed anywhere. It must recognize as inalienable the right to clean water and clean air, a stable climate, and a healthy environment. And there are different ways to say that, but fundamentally that's what it has to say. The Green Amendment, by its placement, by its language, by court interpretation, has to be self-executing, which means that the language in and of itself has the legal force and effect of law. You don't need legislation or regulations to define it or give it legal life. As soon as that language is in the Constitution, if you feel that your right to clean water and clean air has been violated, you have access to the courts based on the language of the amendment. You don't have to find a law that explains or describes what clean water is and what has to happen to protect that right. And the way, there are different ways, a number of ways that this happens, but fundamentally, just for folks to understand, the way the language is written, where it's placed, and how it's implemented must ensure that the rights to a healthy environment are given the same constitutional recognition and protection, again, as all those other rights in the Bill of Rights section of the Constitution. And I misspoke. I said that they have to be written and interpreted that way. The truth is, if you have a Green Amendment that's properly written and properly placed, then the judicial interpretation necessarily must follow, unless a judge isn't doing their job, and sometimes that happens, but we can always fix that. What states have a Green Amendment at this point? There really are only two. The state of Montana has a Green Amendment, and so too does the state of Montana. There are a whole lot of other states that talk about the environment in their constitutions, but they don't rise to the level of being a Green Amendment. If they're in the Bill of Rights section of the Constitution, they talk about things like fishing, hunting, and trapping rights, but they don't talk about water, air, climate, and healthy environment rights. Or some of the constitutional language actually is very beautiful when it talks about environmental rights, but they describe it as being good public policy, or that the way those rights are defined and defended is by the passage of state laws. Well, if your state passes laws that are all about permitting and managing pollution and not preventing it, then you can suffer a whole boatload of environmental harm, and still your constitutional right, the constitutional obligation of legislators, will have been fulfilled, but you're not really better off than where we are, where we stand today. So these other states, fundamentally what they have, if they have something, and there are over 40 states that have language of one sort or another, they're just fundamentally different. Now, what do green amendments do? I'm going to talk first in broad generalizations, and then I'm going to talk a little bit about some specific successes in Montana and Pennsylvania. But big picture, a constitutional green amendment means that every government official at every level of government is duty-bound to protect the environmental rights of all the people of the state. And they must not just protect the rights of present generations, but they become duty-bound to protect the environmental rights of future generations as well. Ideal green amendment language is generational, and that's important. Green amendments fundamentally are a restraint on government action. It means that government cannot take action directly or through approvals that they are given to others to undertake actions or activities that would infringe on the constitutional right to a healthy environment. And it's really important to understand this element that a green amendment is a restraint on government action. That's the way all the other provisions in the Bill of Rights sections of our state and federal constitutions operate. They are focused on the actions, activities, or the inaction of government officials. And so if, for example, you had a polluter down upstream from you that was dumping pollution into a waterway, the remedy isn't for you using the constitutional amendment to directly go after the polluter. Your remedy is to go after the state government officials that permitted that action or activity to happen, assuming that it's a legal discharge. And so you go after the government, you hold the government accountable, who in turn stops the degrading activity, but at the same time, it also puts government on notice that they cannot allow this to happen. And so you start to set a precedent that government officials carry forth against all other like dischargers or in all other like situations. So you have more than an effect just on that one action or activity that's causing harm, but you tend to have a much broader action or activity because now the government officials more fully understand and appreciate that they have to fulfill their constitutional duty in this instance and all other like instances. But that idea of being a restraint on government action, not a grant of new authority, is really important. Green amendments require or make clear to government officials that it's not enough for them to comply with the laws on the books and the regulations that would allow them to potentially permit some highly degrading activity in an already overburdened community when it comes to environmental degradation. But they have to go to the next step of making sure that that decision, whether even if it complies with the statutes and the regulations on the books, making sure that government officials have also done that extra look to make sure that even in implementing those existing laws and regulations, that permitting or allowing this particular action or activity will not rise to the level of a constitutional violation. It is an extra layer of review. It's an extra layer of protection. A green amendment, fundamentally, because it's a constitutional obligation of government officials, it really changes entirely the way government starts to go about doing the business of government. No longer are government officials focused on how do we review, permit, and manage pollution and degradation down the line when it's really too late to do much more than simply review, permit, and manage it. What a green amendment does is it focuses government from the beginning of the decision-making process on figuring out how they can avoid pollution, how they can avoid degradation, and how they can avoid environmental harm throughout the decision-making process, so that they don't simply get to the end of the line and be focused on issuing permits to highly polluting activities that will cross the line and violate constitutional environmental rights. Necessarily, I mean, if you think about other fundamental rights, think about the right to free speech, think about private property rights, think about gun rights. Anytime government officials are engaged in decision-making that could impact these kinds of rights, they don't wait until it's down the line and figure out how they're going to manage the infringement on the right to free speech. Right from the beginning of the get-go, right at the beginning of the decision-making process, they think, this activity we're about to undertake might infringe on the right to free speech. We better rethink how we're going to approach this government action or activity so that we don't find ourselves down the line with a constitutional problem. It just fundamentally changes the entire decision-making process. Also, constitutionally, if your Green Amendment is properly written, properly framed, and the language that we have crafted for Maryland, with Maryland and Marylanders, checks all the boxes. It checks all the highest quality boxes we want and need from a Green Amendment. And so therefore, in its implementation, the Maryland Green Amendment will necessarily require government officials, when they're engaged in decision-making, whether it's deciding to issue a permit or deciding to pass a law, they will have to consider the actual facts surrounding what they're doing. What are the communities that are going to be impacted? What are the situations they're already facing? They're going to have to consider cumulative impact, not just what will this new highly polluting industrial operation mean for this already urban community, but what will this new highly polluting industrial operation mean when we add it to the other 7 industrial operations that are already happening in that community? Does this additional industrial operation tip the scales, overreach, and result in an infringement on the constitutional right to clean air? Fundamentally, in decision-making, government officials have to consider the facts and the impacts, including the cumulative impacts of the decisions that they're about to make, and they have to consider the science. What does the science say about what they're about to do? Because they will not be able to, if challenged in court, they will not be able to defend themselves against a constitutional challenge if they don't do this kind of detailed upfront analysis. Environmental justice is strengthened because every person, every community, regardless of the color of their skin or their income level, their ethnicity, or where they live, have the same constitutional right to a healthy environment, and government officials are duty-bound through the language we have in the Maryland Green Amendment, through the trust language in that Maryland Green Amendment. They are duty-bound to protect all the people equitably. You can no longer sacrifice one community to benefit another. Ultimately, ideally, what a Green Amendment does is make sure that we get good decisions right from the get-go, right? But what it also means is when our government officials get it wrong, overreach, undertake actions and activities that violate our constitutional rights to a healthy environment, people can gain access to the court to challenge that bad decision and vindicate their constitutional rights. Really quickly, I just want to touch on a few specific cases. I know Delegate Stewart touched on them generally, but I want you to really understand that a Green Amendment does make a difference. In the Commonwealth of Pennsylvania, fracking has been happening for way too long, right, since about 2008, and certainly inflicting incredible harm on Pennsylvania communities. But despite the fact that the fracking industry already had it pretty easy when it came to environmental protection in the Commonwealth of Pennsylvania, the Pennsylvania legislature in 2012 passed a very pro-fracking law known as Act 13. Act 13 was going to dramatically change the landscape when it came to fracking and make it even easier for the industry to advance and run roughshod over Pennsylvania communities and environment. It did things like give the industry the power of eminent domain in some circumstances. It gave them automatic waivers from minimal environmental protection standards. It mandated that communities allow drilling and fracking in their residential districts. No longer could they limit it to the industrial zones. It did a lot of bad things. And so the truth is, while fracking was already pretty bad in the Commonwealth of Pennsylvania, it was going to be a lot worse. We knew at the Delaware Riverkeeper Network, we have been fighting fracking for many, many years. We knew when this law passed that we had to find a way to challenge it. But of course, that's very difficult, because it was legislation that was passed by the legislature and signed by the governor. So you don't have too many options. One of the options you do have in that kind of situation, if you can't get the legislature to roll back the law, which wasn't going to happen when it came to Act 13 and Pennsylvania, is you have to look for some sort of higher power. And in the Commonwealth of Pennsylvania, we had a long-ignored constitutional environmental rights amendment that had been added to the Pennsylvania Constitution in 1971, but that for 42 years by the Pennsylvania Supreme Court had been determined to be just a statement of policy and to not really have any legal strength. And so for 42 years, we had powerful language that was in the Pennsylvania Constitution, but it hadn't really changed anything constitutionally or legally for the people of Pennsylvania because of how the language had been interpreted and applied by the Pennsylvania Supreme Court. Fast forward to the passage of Act 13 in 2012, we decided that in our efforts to challenge Act 13, what we, the Delaware Riverkeeper Network, were going to do was try to rely on Pennsylvania's long-ignored Environmental Rights Amendment and try to get the Supreme Court justices to revisit that 42 years of bad precedent. We teamed up with 7 towns that were also going to challenge Act 13. They were going to challenge them on other grounds. One of them was Robinson Township, which is why the caption is Robinson Township, Delaware Riverkeeper Network versus Commonwealth, and you often hear it called Robinson Township. But truthfully, and I say proudly, that the arguments that really carried the day were the arguments that we put forth when it came to Pennsylvania's Environmental Rights Amendment. And long story short, because of Article 1, Section 27 of the Pennsylvania Constitution, the provisions of Act 13 that we were challenging were declared to be unconstitutional because they violated the environmental rights of the people of Pennsylvania. And those provisions of the law got struck down. In the state of Montana, they also have had an environmental rights amendment for a long period of time. In the early years, it was used quite effectively, and then it seemed to have sort of fallen out of favor a little bit, but has been reinvigorated in recent years. But one of the most iconic cases was back in 1999, when there was approval of a very devastating gold mining operation that was going to have serious impacts on the environment and the health and the safety of surrounding communities. And long story short, there was a challenge brought to the approval of this gold mining operation, relying in large part on Montana's Green Amendment, and the Montana Supreme Court rescinded the approval of the gold mining operation, and to this day, it has never moved forward. In the Commonwealth of Pennsylvania, we had another decision where leasing funds that were gathered as the result of leasing public forest land and game lands to the fracking industry, where those funds were being co-opted by the legislators to just fill gaps in the budget, right, to bring it back into the general operations of the state. There was a challenge brought against that taking of those monies that were the result of the leasing of those public lands. And based upon Pennsylvania's Green Amendment, the Pennsylvania Supreme Court said that that co-opting of those financial resources was actually unconstitutional. And because that money was secured as the result of the leasing of the natural landscapes and the natural resources of the Commonwealth of Pennsylvania, those monies must come back into the budget used to protect and benefit those natural resources. In Pennsylvania, a little bit of a different kind of action. Is a very highly contaminated site that is super saturated with dangerous contaminants, very seriously saturated with contaminants, and a pollution plume that is spreading increasingly outwards from the site. The government has known about the dangerous condition at this site since at least the mid-1980s, and we have brought a legal challenge against the failure of the government of Pennsylvania to take any meaningful action to clean up this site, and instead to be focused on figuring out how they can develop the site for residential development despite this highly contaminated condition. The litigation is ongoing, but one of the intermediate court arguments that took place, responding to an effort by the state to get our case dismissed, resulted in a ruling from the court that very clearly said that the failure of government to act could be the basis of a violation of Pennsylvania's Environmental Rights Amendment if that failure to act perpetuates an unconstitutional condition when it comes to environmental rights. And then just more recently, as I said, Montana's Green Amendment, it was used to some really great effect around the late 90s, early 2000s, and then we didn't really hear that much more about it. But I like to think that they've been inspired by our National Green Amendment movement to take a second look at their Green Amendment. And don't know if it's true or not. I like to think that. But anyway, in April of last year, as recently as April of last year, we had another situation where there was a highly degrading gold mining operation that was approved by government officials. And using, in part, Montana's Green Amendment, the approval was struck down. So hopefully you can see, right, that Green Amendments really make a difference. And it's not just Maryland where we've been successful in getting a Green Amendment proposal. We right now also have Green Amendments that are advancing in New York, New Jersey, and West Virginia. And we're anticipating 2 more announcements just in the next couple of weeks, as well as some planned for introduction at the beginning of the 2021 legislative session in some other states, which need to wait a little bit longer to get to that point. But really this movement, this National Green Amendments for the Generations movement is really taking hold in powerful ways. As I said, in Maryland, the Green Amendment, because of the activities of our coalition partners, all of us working together on that beginning slide, we've decided as a collective, as a Maryland community, to call Maryland's Green Amendment a constitutional amendment for environmental health and justice, to really send the message that this is about healthy environments, healthy people, and healthy environmental justice. And I think that that's a powerful name. So with that, you know, I guess it goes without saying, I believe that we all have a right to a Green Amendment, a constitutional right to pure water, clean air, a stable climate, and a healthy environment. And with this Green Amendment movement, I'm hoping that in the not too distant future, we get them in every state across the nation, and then ultimately as step 2 at the federal level. But we need to start with the states.
Great.
And I yield back.
Thank you so much for that, Maya. That was really good. We had one really great question, which I was planning on asking myself, which is, who defines what clean air, pure water, a healthy and healthful environment, and a stable climate look like? Who is the person or entity that defines that?
Yeah. So it really gets...
Sorry, go ahead.
Yeah, so it really gets defined in a couple of ways. First off, that kind of broad language is emblematic of every constitutional provision in the Bill of Rights section of a constitution, right? And so if you think about it, what does it mean to be free from unreasonable searches and seizures? What's unreasonable? What's a search and a seizure, right? When you think about the right to free speech, really, what is the right to free speech? Can nobody tell you to shut up? Or can you be told to shut up by some people in some circumstances, right? And so just by their very nature, Bill of Rights provisions use broad language to be able to cover the array of issues that have to be covered by that provision, and also to allow them evolution over time, right? And you can think about that. Think about free speech, right? When they wrote the Bill of Rights provision about free speech, we didn't have technological free speech, and yet the constitutional right to free speech has implications when we talk about technological communications as well. So with that being said, when you talk about pure water, clean air, a stable climate, and a healthy environment, in part, those things will be defined by the legislators as they're engaged in legislative actions and activities. In the first instance, they will try to think about, define, and protect those rights in the Constitution. So we will all get some definition and some understanding through the traditional legislative process. But in the final analysis, deciding whether or not the legislators got it right in one context or another, or in those arenas where the legislators haven't spoken at all, it will be up to the justices in the court to bring forth that definition. And as with all constitutional provisions, using traditional tools for constitutional interpretation and legal interpretation of terminology of all kinds, our judges are well equipped to do that body of work, going through the case-by-case analysis that will result in the clarity over the definition. So it is, in the final instance, it will be up to the judges and the justices to, in individual context, say, yes, we got it right, we got it wrong, this is a violation, that isn't.
Great. And you hit on this throughout your presentation, but just to make things clear, does the proposed Maryland Amendment expand government power?
No. The Maryland Green Amendment is a restraint on government authority. Like other Green Amendments that exist and that we're working to advance, and like other provisions in the Bill of Rights section of the Constitution, what we are saying with the passage of this Bill of Rights constitutional amendment is we are saying to government, like with all other provisions, when we give you permission to govern us as a people, we are holding unto ourselves certain rights, certain inalienable rights and freedoms that belong to us, which we are not turning over to you. We are saying to you, when you legislate, when you regulate, when you govern, you can do all the things you need to govern, but you may not carry forth that governing activity in a way that overreaches and infringes on these fundamental, inalienable human, civil, and political rights we hold dear. And amongst those things that we are reserving unto ourselves and saying, you may not govern in a way that takes these rights away from us, we are now saying that amongst those rights that we are reserving unto ourselves are the rights to clean water, clean air, a stable climate, and a healthy environment. So just the way you would think about speech rights and gun rights and freedom of the press and due process rights, think about now environmental rights being treated the same way. They are protected from actions, activities, and inaction by government that would infringe on those rights. It's not a grant of authority, it's a restraint on authority.
Awesome. All right, and then last question before we move along to Tamara. You mentioned some efforts in New York, New Jersey, West Virginia. Are any of those really hopeful? Are there any sort of actions coming up soon on those?
Yeah, every single Green Amendment effort is at a different place. And how quickly they're moving depends a little bit on the constitutional amendment process. I will say New York requires passage twice by two different consecutive legislatures, not legislative years, but you have to have one legislature pass the amendment proposal in both houses. You have to have an election, and then the next legislature, once it's seated, has to vote as well. So they've got a 1-2 punch, and then it goes before the people. In New York, we've already had that first passage. That happened last year in 2019, which was, really powerful and important. And so in 2021, we'll have the opportunity for second passage and then for the amendment to go before the people. In the state of New Jersey, we're also having really great progress. In New Jersey, depending on how high the vote count is, we may only need passage once by the Pennsylvania or by the New Jersey legislative houses. And so it is possible that by the end of this year, we will have a New Jersey Green Amendment that goes before the people of New Jersey for a vote. Or we might have to have 2 votes like they have in the state of New York. In New Mexico, where we don't yet have a legislative proposal, but we're gearing up for a proposal to be put forth in their legislative session in January of 2021, in New Mexico, you only need a vote by both houses where the amendment is passed by a majority of the legislators in each of the houses, and that only has to happen once, and then it goes before the people. There's tremendous energy and enthusiasm in New Mexico, so it's possible in New Mexico, with the way things are going, we might also have an amendment brought before the people by the 2021 election in November. So, and in all the other states, right, it's all happening in different ways, but I think that there's a lot of positive energy and there's a lot of reason to expect some really powerful forward movement in a number of states in the coming 2 years.
Great, thank you, Maya. And one more question just popped up. Is there a way to link the precautionary principle to the Green Amendment to give it more teeth?
The Green Amendment, and if you read the book, The Green Amendment, it's one of the things that I really focus on. A Green Amendment, properly written, framed, and placed, is by its very nature based on the precautionary principle, because it requires government to focus on prevention of pollution, degradation, and harm, and it requires government to consider the science. And so if you are in a situation where you have something like per- or polyfluoroalkyl chemicals or glyphosate or any other new chemical or contaminant that suddenly is being brought forth and being used by industry, there's a very powerful argument to be made under a Green Amendment to say to government officials, if you do not take action to ensure that this chemical and its use is safe before you allow it to be used, either by permitting it or by doing nothing about it, like they did with PFCs, that could actually result in a violation of the constitutional right. And as the Montana Supreme Court said in that early MEIC case, when you have a Green Amendment, when you have a constitutional right to a healthy environment, you don't have to wait for the fish to be floating dead on the top of the water to take action, right? If we can bring forth the information to show that there is a high likelihood or possibility that you're going to have the fish floating dead on top of the water and the kids getting cancer, and that government hasn't looked at the science, the facts, and these implications, you could have a very strong argument to say that something that they have done or haven't done is a violation of the Green Amendment, and that necessarily is the embodiment in large part of the precautionary principle. So great question, and absolutely, it's fundamentally part of what a Green Amendment is and how it operates.
Awesome. Thank you so much, Maya. We're so grateful to have you as an ally on this work and a leader on this work. All right, well, let's move along. Next we've got, last but not least, is Tamara Told-Laughlin. She is the North America Director at 350.org, but she's also the former leader of the Maryland Environmental Health Network, who was a big part of championing this effort last year in the Maryland legislature. So Tamara, why don't you go ahead and take it away?
So I'm just going to, while we're waiting for Tamara, there's this question about the Ninth Amendment. There's also a lot of conversation, great conversation about Our Children's Trust litigation, which tries to use life, liberty, and property language in the federal Constitution, and also the public trust doctrine at the state level, but primarily the life, liberty, and property language to advance in the federal Constitution to advance this idea of a right to a stable climate. These are all powerful and important efforts and arguments, and I certainly hope that Our Children's Trust and their litigation is successful. But they are not mutually exclusive. And if the Our Children's Trust litigation is successful, it doesn't displace the need for green amendments at the state level or at the federal level, because its focus is primarily on climate. At the state level, a lot of their litigation has to do with the public trust doctrine. And what we can see in the different states and how they talk about the public trust doctrine, it is very state specific, and often, unfortunately, that litigation is not succeeding. And it depends on the state for the hows and the whys it's not succeeding. But what this shows to me is, first off, green amendments are not mutually exclusive with all of these other powerful and important efforts. But that a green amendment is, in my opinion, the strongest tool that we can have in the toolbox if we can get them passed. Because we are not hoping that any justice or government official will read into less clear language what we hope they will read into it when it comes to rights to clean water, clean air, a stable climate, and a healthy environment. We're not leaving it up to them and their personal opinions or how they interpret language. We are being very, very clear through the language of the Green Amendment. This is what we mean and want. Is that Tamara?
Yes. Hi, everyone.
Great. I'm so glad that you were able to get that figured out, Tamara. And we're so happy you could join us on this Monday evening. So with that said, do you want to go ahead and take it away?
Sure. So this being the third day of Black History Month, I like to start these kinds of conversations with a good visual about how I ended up in this work and why I care about it. And it's always pretty funny to say that after this photo, you can no longer say that you haven't seen any Black people in nature, because by virtue of looking at the slide, you have. So I think it's important for us to sort of connect to why we assume we would have the right to a healthy environment, with Delegate Stewart brought up. A lot of the points that Maya made around setting the groundwork for continued action. And for my part, I want to talk a lot more about the climate decade and why Maryland is a really prime place to start this work. As Caitlin mentioned, I am formerly the executive director of the Maryland Environmental Health Network in Baltimore, and are also a resident of the state of Maryland, and I live in Baltimore, in a part of Baltimore that manages to be in District 40, 41, 42, and 43 at the same time, depending on which street you're on. So I have a fair amount of interest in Maryland maintaining its progressive image and forcing it to do so in the daylight. So the slide that you're looking at, that you should be looking at now, is slide 47, which is a little bit about the person who brought me into this work. Rabbi Nina Beth Carden came to me about 2 years ago and said that she felt like this work was really important for the next phase of what has to happen in climate work. And she's a very convincing advocate. So in a small amount of conversation, an environmental health organization got into this fight to really raise up the call for protection of our rights and not just prevention and adaptation to harms that have already come. So a little bit about me, just to follow up. If my entire life could fit into one set of slides, and one slide in particular, this would be it. My core values are here. The framework for why I don't believe that you can have work-life balance, because where your work life is one life, and the spheres of influence where I can call someone to help explain, to help me learn something that I need to know about this work. So just a bit about why I'm here. To follow on there, these are a few of the places that I mentioned in the sphere of influence where I do this work, and I'll move really quickly through this so we can talk about what I think is going on in Maryland and why it's so important. There are a bunch of different bodies where I'm sometimes able to push for more progressive activity, but as we know, it's time for more action even in our current state of play. And I have moved to 350.org, where I'm the North America director, so that covers the U.S. and Canadian programs, and as the global vote for both of those programs in the international part of the organization. And I moved there specifically because my experiences in Maryland helped me to realize that it's important to have great ideas, but it's even more important to have great ideas and a lot of people to talk to about it. So I'm glad we're all on this call tonight to talk about how do we move to the next phase of work in climate that really protects the next generation, and how do we boost the information that we have from many years in this work. That way the folks who are out doing this for the first time don't have to fall through the pitfalls that many of which were mentioned by Maya in terms of the legislative and legal history of trying to protect our rights in this context. So it's a little bit about my work at 350, and I really want us to focus on why now is a time for a constitutional amendment to protect people and the planet. I wish it were as easy as it sounds, so we're just going to talk a little bit about how we got here and what we are expecting. And the point that was made earlier about the polluter pay principle is a really big part of this story. So if you're looking at the slide, there's a really good timeline for environmental justice activity in the federal government. Starting in 1968, 1983, 1991, there's just so much to say about what we have been able to do as organized people to do this work, down to the executive order, which is a thin thread between what we call justice and what we accept, and lots of moments where we have really thought clearly about how do we work together to protect the future. In 1998, the Wingspread Statement and the Precautionary Principle really took off as a way to wrap the science, the technical debt, and the need for human health to be raised up in the same conversation. And in Maryland, that looks a lot like the Maryland Environmental Standing Act, which would be enhanced by what's being proposed here. So policy models, it's really important for us to talk about why we would propose another layer of protection in a progressive state like Maryland, mostly because it strengthens the environmental law that currently exists. And when I first wrote this slide deck, we weren't in a situation where we had so many of the bedrock principles of environmental law being rolled back at the same time. And to then, at that point, we were lucky enough to be beneficiaries of the most robust set of environmental laws in the world's history without the layer of a constitutional protection. But if we're strengthening the policy across the federal space as it evaporates, it's mostly going to be through a network of state actions that rise to the occasion to protect people's health and safety at a really basic level. And that's going to happen through work that gets done in our state houses. So thinking through why we would need to move from CERCLA and RCRA and NEPA, which are under attack, Clean Water Act, and Endangered Species Act, and the entire lattice work of protections that we have, is that even with all of that stuff, we still manage to fail to protect people from a fate worse than death because they live in a place where their human health issues become psychosocial issues, which become issues of access to the levers of power. And some of that is built into the way the environment has always worked. So this slide deck are some of the founding fathers of environmental work. And if you look, there aren't very many people like the ones who inherited this land who have been in this space. And so it is not a surprise to find out that at this juncture, we're still in a space where we do not have a comprehensive set of protections for people showing up in community to avoid being harmed. I'm going to move past, let's see what's going on. Something weird happening. Caitlin, can I ask for your help to advance the slide deck because something weird is happening with the, let's see if I can do it. Let's see if I can do it. Awesome. So in looking at the state of play, before we talk about the robust environmental protections, we have to recognize that even in that scenario, post the development of the U.S., things have not been equal. So these boxes represent all of the different pieces of what we refer to as the American landscape in terms of environmental protections, and underneath all of that is all of this other law that really excludes communities, whether it's identifying people by their ethnicity, determining that nationality means people don't have a right to access to air quality and water quality and human health, or to stay on the lands that they were born on. These specific activities are a part of the legacy of injustice in the U.S., which will have to be dealt with through another lens. So that lens is an equity and justice lens. Why? Because just transition and fairness and equity have to be informed by a concentric circle of people who are experiencing harm and stakeholders who are in line and as allies to make sure that we incorporate the means of protection for communities into the future. Why? Because what we promote or what we don't ends up impacting the health of multiple generations. It's really an incredible moment that we're able to work together in this time across all of the areas of work represented on this call. Advocates and lawyers and water keepers and activists in the street are working together because a constitutional amendment in the state of Maryland has some real power in a time when we're feeling fairly powerless to stop the continued degradation of land, water, and air. So for Maryland, this is particularly useful because the constitutional amendment is a natural successor to the fracking ban. Almost everyone in the state has some relationship to how that battle was won, but what we have not done is think about what we were not going to get by winning the battle against fracking. And one thing we haven't done is to develop prophylactic protections which give people the right to a health in perpetuity. And so this fills that gap in a way that standing does not, because it expands the ways that you can get into the work, which Maya talked about, rather than narrows the opportunity to protect your own health. So in the state of Maryland, we're super focused on the idea that being able to protect against actions that have deleterious impacts to the environmental health and safety, it means we're not relying on people being injured as a way to get in the door. We're not waiting until people are already hurt. That way we're not putting onto communities who already have the compound burdens and being cited into sacrifice zones, not having enough access to levers of power and decision makers, and then asking them to suddenly become scientific experts on how it is they have ended up in that position. It's just a little too much for looking at 10 years to fight climate. So in thinking through the power of a Green Amendment, really it helps to raise up environmental health violations, which some that we've been dealing with in the state for a long time have been landfill construction and maintenance, toxic waste dumping, air pollution, and the all-important set of climate change catalysts that the state of Maryland has failed to regulate in my time here and in the time of everyone else who's been working on these issues. So in trying to protect the basic things that we count on, this amendment would fill a lot of gaps. So Delegate Stewart talked a bit about how the bill becomes a law, so I want to skip into a conversation about what has to happen in the state of Maryland. So this is the second year for this amendment coming to the floor, and what it needs is people. It needs people to mobilize around a great idea, to articulate to those folks in power what it will do to have this amendment in action, and to move them past their fear that they will not be supported by a public who voted them in the office. In the year prior to this one, we had heard from a lot of folks that this is a great idea, but what people need to see is that they will have political cover to do the best thing. And the best thing is to provide people protections before they need them, to protect the next generation before they are imperiled to a poor environmental health and a degraded environment. It's best for us to move now while we can before the clock runs out on our species. So all things being equal, it's important for us to walk away from this call recognizing that if we do not mobilize, if we do not tell the people who sit in those seats that they are using our capital, our capacity, and our votes to do things that support us, we need to motivate them to stay in. That was odd. We need to motivate folks to stay in line with the folks who put them in office, and we need to activate their power by letting them know all that we are asking in this moment is for the opportunity to have this measure become a referendum, which means the folks in the legislature, the buck doesn't stop with them. What they do is put this in line for people to talk about what it means to demand uncontaminated water, breathable air, and a healthy environment now and into the future. And the fact that we hold these rights as stewards and in a benefit for people who have yet to be born is a pretty incredible opportunity, and one that has to happen because we demand it. So here are just a couple of thoughts about what it looks like to mobilize and what it would look like for us to really think through the state protection, and finally for us to figure out how we push past the anxiety of a House and Senate that really do have the faith of the people to move forward. We have to recognize that there is no time other than now to make these moves, and if we do not act directly in our own best interest, we can't wait for others to do it. So other folks have talked about the fact that we're not the only ones to have done this. So the more important pieces for us to think through is that in the amendment in this context strengthens environmental law and is a backstop for future legislation. So what that means is you cannot go higher than a constitutional amendment, which means we'll be doing the most we could do to protect our health and our future by taking this action. So I wanted to talk for a second about how this kind of action is a precursor for what's on everybody's lips across the country and really across the world. As the Green New Deal becomes a thing that people say over and over again and try to figure out how we respond to it, this kind of legislation, the referendum it would allow, is a precursor to what really what could happen in the world where the Green New Deal becomes realized. We cannot protect people's jobs, we cannot build new infrastructure, and we cannot protect people's health if we are not thinking clearly about the state's role in making that true or making it false. And part of why this is an action we have to take together is because we are up against an entire history of doing things that only benefit the loudest voices. So because we are dealing with cultural norms of oppression and racist standards and science that is not allowed to speak to the truth as it's happening and gives us false choices that we fall into and then fight about. So in the real world where we have to explain to the public who will have to vote on this, we have to confront that no community, group, or people should bear an outsized burden of environmental threats, and that poverty itself and people being harmed because they are sited and zoned into the wrong places is a function of design and not a function of biology. So as all of the panelists have spoken to, we are in a moment where we need to think very clearly about jobs, pollution, and public health. And the amendment gives us some real ground to be able to have a public dialogue that moves the needle on that conversation. So all things being equal, I have said quite a bit about what we need to do together, but I think it's important for us to recognize that this piece of legislation is also a moment to work across sectors that we have worked in as people who care about human health, the environment, and the future. And so because we cannot get enough money from a lawsuit to make people's lives whole, because we cannot resolve every harm that's ever been done, the best thing we can do is avoid causing people more harm. And here's just a little bit of contact information if you want to connect with either myself or with Nina about how all of this is going. But it's really important for us to think together about what the future is going to look like and to take action while we can. And an election year is as good as any to make climate the number one thing that a voter cares about. And I'll yield my time if there's any left for comment.
So thank you so much, Tamara, for your presentation. We had a question about who was involved in this work. So not only does Tamara sit on our steering committee as a representation of 350.org, but myself, Waterkeepers Chesapeake, we're supporting this work. Nina Beth Carden for the Generations, Central Maryland Ecumenical Council, Maryland Legislative Coalition, and Earthworks all sit on the steering committee for this work. And a whole host of other environmental groups and public health groups also have said yes to this campaign, and they want to be supportive in any way that they can. But Waterkeepers Chesapeake and For the Generations and 350.org, along with Maryland Legislative Coalition and Central Maryland Ecumenical Council, and then lastly, Earthworks are the primary organizations that sit on the steering committee and are helping move this work forward. All right, any other questions for Tamara before we jump off the line? I think I'll just ask one question, Tamara, on my end, is if we had the Green Amendment, for instance, passed in the 80s, what more recent projects do you think, or even just one example of a project in Maryland that came through, maybe that we could have prevented or it could have been built elsewhere if we had the Green Amendment in place at the time?
Thanks for the question, Caitlin. I think the numbers of their entire communities whose existence is formed because they are survivors of being in sacrifice zones for various reasons, whether we are talking about oil trains running through Baltimore or the widening of highways for no godforsaken reason. There are many numbers of permits, statutes, regulations, and activities that go on in the state of Maryland, where because we do not have litmus tests for whether or not viability is measured against human health impacts now and in the future, we do not have a measuring stick. So when we show up in space to argue for protection of health and safety for people who live in the state, we're up against a lot of numbers and a different story, which is much more about whether or not a thing is affordable, whether or not it will bring a phantom number of jobs to a vanishing number of people, without consideration of whether or not the externalities of building something today causes people's harm in the long run. So if we think through any number of questions that we are thinking about in our public consciousness, the question should really be, did we consider human health? If we're talking about actions that come through the Public Service Commission, if we're talking about the widening of highways, if we are talking about whether or not an entire field of trees can be cut down to provide equal access to fossil fuel import-export facilities, all of those things are happening in Maryland at this time.
Great answer. All right, well, we've got 2 minutes left. There's been a few things linked in the chat box, but we'll make sure to get our action alert out after this call for any of the webinar attendees. And I've also got some instructions on how, there it is. You can see the link right there on the slides. And that action alert will, is essentially what Delegate Stewart was talking about earlier. You put in your address and it links you with your senator or your delegate. And then we've got some form language that you can use and customize to make your own, to send in emails or even a phone call if you're willing to do that. Because right now we need our lawmakers to hear from everybody across the state that this is something that they want and that this is something that is fundamental and that we need. So with that said, thank you all so much for joining this call on a Monday night. There's some more information that's been linked in. Our email addresses are there, so if any more questions come up, feel free to go ahead and email us there. But we're so excited that you were able to join us, and we're really excited to keep moving forward on this work and hopeful for the passage of some legislation this year. So thank you all again, and hopefully we'll be connecting soon.
Thanks, everyone. Keep up the pressure.